Okay, so we are continuing with this series, the Torah in its ancient Israelite context, which is taking Dr. John Walton and J. Harvey Walton's book, The Lost World of the Torah, and seeking to explain its thesis, to walk through what it is teaching, and then, of course, add in my own observations, illustrations, and whatnot to help with that process. So we already looked at part one. If you missed part one, go back and watch that first if you want, because it'll help understand where we're at. Part one explained that the Torah is an ancient document and all that that means. Now we're going to talk about law and how it existed in the ancient world and how that contrasts with the modern way of thinking about law. So this is the second video. It's labeled as 1A in my PowerPoint presentation, but this is number 2. So let's dive in. Let's see what we have to learn here. So we're going to talk about laws and legislation in the ancient world versus the modern world. And of course, Schoolhouse Rock came to my mind thinking about legislation. So let's look. We're talking about the difference between legislation and instruction, because there is a difference, and that's key to understanding this distinction. So written documents that are prescriptive expect obedience and or conformity in response. The definition is at the bottom, right? It's relating to the imposition or enforcement of a rule or method. In other words, if you write something that's prescriptive, you're expecting that the people involved are going to conform to it. They're going to obey it. In contrast, written documents that are descriptive expect you to comprehend. That's your response. Understanding and wisdom is what we're going for here. So that's just describing the situation without judgment, but simply saying this is the situation, this is what's what, because you want people to understand, you want them to gain wisdom. And those are two different ways of approaching the idea, of course, of getting people to understand an issue and come to the right conclusion. One says, here's the rule, do it. The other says, here is wisdom, choose it. That's basically the two ways of thinking about these written documents that we are looking at here. One of them is modern, one of them is ancient, as we will see. So it's only in recent history, and again, going back 500 years, that's recent history when we're talking about the ancient world and the Torah and all of that, right? We talked about that in part one, how many thousands of years it has been since Moses, roughly 3,500 years ago. So it's only recent history, post-Reformation, that the idea of laws as prescriptive really took hold. So the modern way of thinking about law is part of a legal code, right? Any TV show, any movie that shows the lawyer's office, they got that giant set of books, right? Book after book after book. Those are all of the precedents, all of the case law that they would need to consult for a particular client and situation. But prior to the modern era, and still true in some non-Western parts of the world, law was more flexible than a legal code. Society was regulated by customs and norms, right? So again, the way that things worked was the way that the culture, the customs, the norms prescribed. Judges, whoever they were, whatever they were, who were those considered wise in the traditions of the culture. To be a judge in the ancient world, and really up until, again, the rise of modern governments, modern societal structures that happened after in the wake of the Reformation, until then, a judge wasn't a job. It was a person in that culture who was wise. Typically, they were an elder, right? Someone older, but it was someone that understood the culture, someone who knew how things should be. They weren't educated for that. They made their rulings based on insights and wisdom. All right, so you were a judge in your village, in your town, in your tribe, because you were considered wise. People trusted you to understand situations and come up with good answers to them. It's not because you went to law school. All right, again, that's modern versus ancient. And we got to understand this distinction, of course, because we're in one and the scriptures we're trying to understand were written in the other. So when we speak about the ancient Near East in particular, right, it's not just a not being governed by a legal code like in the modern world, it's actually a non-legislative society. So in such cases, the legal structure is not based on written documents. Written documents serve an entirely different function. Again, in the ancient Near East, and we're going to look at this example as it gets explained here, there just isn't a legal code. There isn't a written document that represents legislation because nobody is passing legislation. There is no such thing. It doesn't exist yet. And these are ideas that will be developed in this part and in the next part of this series. So here's an example, right? The most famous example outside, of course, Moses and Mount Sinai is the Code of Hammurabi, a wonderful archaeological discovery. So what it is, the Code of Hammurabi, is examples of rulings, right? Here's a ruling, here's a ruling, here's a ruling. It's just a list of rulings that provide wisdom to future judges when they deal with a similar case. This is what happened before. I've got a similar case. Do I like that? Do I go with that? Do I change that? It's an example. It's not a full-fledged legal code that some judge is duty-bound to enforce. Nobody's enforcing a code. It's not the way the ancient Near East worked. So there's a picture of the Code of Hammurabi. It was written about 1750 BC. Again, depending on your arguments for the date of the Exodus, this is a ways before Moses. It was discovered at Susa. There are 282 sayings on it, but major areas of legal importance, especially to them, aren't addressed at all. There's nothing about the kingdom's fiscal policy. There's nothing about animal husbandry, which again would have been many of the times that a judge was needed to settle a dispute would have been about fiscal policy, right? About taxation, about coinage, any of that kind of stuff as the kingdom developed, but also about animals, right? There are so many people depending upon them. And yet you don't write anything about that? That tells us something. So what's the code's purpose, right? Again, and because it's called the Code of Hammurabi, that's a little bit misleading, just as the law of Moses is a little bit misleading, again, because there is no legislation in the ancient Near East. So what was it, the Code of Hammurabi? It was Hammurabi's demonstration to the gods. He's their regent, right, on earth. It's his demonstration, I am executing justice in my kingdom. I'm doing my job. Here are some examples of me doing my job. These are the decisions that were made. So judicial practice in the ancient Near East. So in none of the extant ancient Near Eastern legal documents, and let's pause for a moment. Anytime we're dealing with the ancient world, we can only work with what is extant, right? If documents, if archaeological evidence did not survive the ancient world, we can't use it because it doesn't exist anymore. So we go with what we have. And you would think that if they were a legislative society, if they did have a legal code, we would have something, right? We would have something because we've got a lot of this archaeological evidence, but in none of it is there a legal document that makes a reference to a resource being consulted by a judge before a ruling. Again, never does a judge say, let me look up the precedent. Let me look at the code and see what I'm supposed to do. That's just not how they operated as judges. In the most famous one, Hammurabi's code is never cited by a judge as the basis for the judge's decision. Here's the quote. Judges in the ancient world didn't issue their verdicts by making reference to documents that had been produced for that purpose. Instead, they depend on custom and wisdom. When those were inadequate, divine oracles would be sought. Again, this is not the way our legal system works, right? Lawyers are up in front of the judge, they're arguing, they're citing precedents, they're citing Supreme Court cases, all of that kind of stuff. And when judges make their rulings, 60, 70, 100-page rulings, there's all sorts of references to prior legal cases and legal doctrines and whatnot. That's how a legal code, a modern system works. That's not how the ancient Near East worked. Judges didn't do that. Again, we have no evidence that judges did anything like that. And when they couldn't solve something, right? When a case was a mess, they sought the gods' will directly by going to a priest and doing what their particular culture said you needed to do to get a divine oracle. Let's keep going. So these conclusions are based on the analysis of thousands of surviving ancient Near Eastern legal documents. Again, and in none of them does a judge do that. So Israel, let's focus on the Torah and on Israel. Israel, while containing significant differences with their neighbors, again, obviously, in the realm of legal thinking, the Israelites were much closer to the thinking that existed in the ancient world than that they are to the way that we think today. Again, they weren't exactly like their neighbors, but they are much closer to their neighbors in the ancient Near East than they are to us. And that's the idea of the cultural river that we developed in part one of this series. The idea that the way we think, the way that we understand, is conditioned by our cultural setting, and we think like modern Westerners, and they think like ancient Near Easterners. And so we are not going to think about the law the same way. They think more like their neighbors, again, with some exceptions, than they do us, and vice versa. We think more like our neighbors in the modern world than we do like them. So, conclusion, right? As perspectives about law shifted over the last couple of centuries, right? Dramatically did, with the rise of the modern nation state. We began to interpret the Torah in light of these new perspectives. Specifically, we began to treat Torah as if it were prescriptive, codified legislation, though that concept didn't exist in the ancient world. So that's not an overstatement. Again, this is the one point you need to take away from this, right? No culture in the ancient Near East thought about laws in terms of an established legal code that applied to everyone in every situation. That's just not the way law worked in the ancient Near East, because it's a non-legislative society. They didn't have that concept. It had not yet been developed as an idea, as part of their culture. So people in the modern world, interpreting the Old Testament, specifically the Law of Moses, started to look at it like our kinds of laws and read that in. What were the consequences? As commonly happens, interpreters were inclined to read the biblical text through the filter of their own cultural river, their own cultural context. Pause for a minute. It's hard for us not to do that, because that's the one we know. That's how we think. It's hard for us not to read that into something from a different culture, from a different time, and not understand where the disconnect. Okay, keep going with the quote. As a result of such a reading, people began thinking that the Torah dictated the law of the land to Israel. And since it was considered divine revelation, it was therefore construed as God's ideal guide to society and morality. And if it's God's guide to the ideal shape of society and morality, then all people everywhere are obliged to apply it. This chain of logic all begins with the false assumption that the Torah represents revelation of the prescriptive, codified legislation given by God. And since that's not true, since it's not that, the whole dominoes of saying, this is the ideal legal framework for all people in all places and all times. Again, I've dealt with personally for the last several years a Hebrew roots movement group that claims that that's exactly what Torah is. The legislation from God revealing his divine will for all peoples, all times, all places. The problem is, that's not how the ancient Near East thought of these things. Not at all. And so therefore that whole chain of events breaks down. So what are the implications? And this is our last slide, and we'll wrap it up here. Every time a theologian, a pastor, a politician, right, has claimed that God's unchangeable law requires this or that corresponding measure in our own legal context. Again, our legal context is a codified prescriptive code. Theirs was not. They cite the Torah or something else from the Old Testament as the basis for that claim. That person is using the Word of God in a way incomprehensible to its original audience. And again, that's a problem. That's a failure of interpretation and a failure of application. Because if your interpretation is faulty, your application's liable to go awry as well. But so when you hear someone say, this is God's unchangeable law, then you already know that they don't understand what the Torah was to the ancient Israelites, to Moses and his people. Because it wasn't like that for them. That's not the way the law functioned. We're going to, again, in subsequent parts, we'll dig into this more. We're laying the foundation now. We'll dig into to how that looks and what that, and all sorts of examples. So let's just look at some examples from history, right? Going back the last 500 years or so, when people have said, the law said, the law of Moses says this, so therefore in our society, we need to do the same thing. Justifying slavery by citing its allowance in the law of Moses. Antebellum South, pastors all over the antebellum South were saying that, look, here's slavery allowed in the law of Moses. God must approve of it. Therefore, we need to do it. We can do it too. They were using the law of Moses in a way not comprehensible to its original audience. Also, of course, much more benign, but also using the law in a way that its original audience would have understand, would be to say Sunday work restrictions should copy those of the Sabbath. We're going to move it to Sunday, but we're going to ban all work because of the Sabbath. Interracial marriage bans. Again, looking at the law of Moses, seeing some things and saying, let's just apply that here. The death penalty for witchcraft, Salem witch trials, among other examples. Bans on usury. Again, in the law of Moses, you could not charge interest to a fellow Israelite. And throughout the Middle Ages, that was something that the church said, well, we have to copy that. And then I just saw this in the last 2 years. I saw a pastor arguing that in our legal code, no man should be convicted of rape if it's only the woman he raped who accuses him, because there needs to be two witnesses, because the law of Moses said there needs to be two witnesses. And I wrote about that. It shocks the conscience that he would be defending and saying as long as a rapist doesn't leave witnesses, they can never be convicted. Right? Blows the mind. But again, we have a codified legislative legal code. It is a very different system than what they had in the ancient Near East, where judges are using their own wisdom. And these documents are examples of the kinds of rulings that judges should make. Not that they must make. Again, we'll dig into this more. I don't want any of these parts to get super long, so I will continue to unfold this case, this thesis, one step at a time. Hopefully you'll be able to follow along. You can, of course, ask questions. We can have a healthy conversation in the comment section. Thank you, and God bless.